every partner is liable for all the acts of the firm done while he is a partner. If liability has arisen during the period while a person was a partner, such liability does not come to an end by his retirement. Accordingly, there is a scope of discharge of liability of a partner if any agreement is made to that effect with the third party as well as other partners of the firm, and such agreement may be even implied by course of the dealing. The decision in K.J. George versus State Bank of Travancore 2000 is an example of novation whereby the retiring partner was discharged from his liability towards the creditor bank. In the said case, the respondent bank granted overdraft facility and medium-term loan to a partnership firm, which included defendant as the partner. While this amount still remained unpaid to the bank, the defendant retired from the partnership firm. The notice of the partner was duly sent to the bank. Thereafter, revival letters in respect of the loan and a subsequent agreement was entered the bank and those partners who continued in the business. The retiring partner was not a party to the revival agreement entered by the bank. Moreover, the entire liability was taken over by the continuing partners. The bank also never required the defendant to sign the revival agreement. It was held that the bank had accepted that the partners of the reconstituted firm alone will be liable for the debts of the firm. In Syndicate Bank versus RSR Engineering Works 2003, it was held that in the absence of an agreement discharging the retiring partners, they would remain liable towards the pre-retirement liability. Liability of a retiring partner can be discharged by an agreement between the retiring partner, third party, and partners of the reconstituted firm. Such an agreement can also be implied from the course of dealing between the third party and the reconstituted firm after retirement of the partner. By retirement, a person ceases to be a partner. The third parties can still presume mutual agency between the outgoing and continuing partners until a public notice of retirement is given. It is therefore in the interests of both the retiring and the continuing partners that public notice is given. In a case before the Bombay High Court, Glorious Plastics Limited versus Lughate Enterprises, 1993, a partner retired and some 3 years later the continuing partners incurred liability on a bill of exchange. The retired partner was held not liable for the same. It is provided in section 32 subsection 4 that such a notice may be given either by the retired partner of the reconstituted firm. No public notice is, however, necessary in the case of deceased partner, insolvent partner, and a dormant partner.